So, friends, the topic for discussion today is going to be on breach of contracts. So, when a contract is made, it's often trusted that the contract will be performed by the parties to the expectations of the other. Obviously, obligations between the parties have to be fulfilled and completed. That is what we call as discharge of a contract. And one of the mechanisms of discharge is by discharge by performance. Substantial performance is also a ground. We have discussed that in the past. But if performance does not happen, then a breach occurs. Now, interestingly, when breach of contract occurs, you will notice that it is one party who either fails to perform his duty under the contract, or where it becomes probably impossible for him to perform, but that impossibility is probably beyond Section 56. We'll talk about that a little later, where we talk about the doctrine of frustration. Or he has either very clearly communicated that he has no intention to perform. So the contract is made, but he has communicated that he does not intend to perform. This is when probably we say that there has been a breach of contract. Right? Now, when contract has been broken by one party, the other party is often called as the aggrieved party. And what we have to now discuss is what happens when a party who is aggrieved due to breach, what kind of remedies can he seek from the court of law? Now, the basic remedy that comes to anyone's mind is the remedy on damages. Right? So damages is considered as one of the key remedies for breach of contract, apart from the other remedies that we can always speak. And you will notice that the law on damages is specifically mentioned in the Indian Contract Act 1872. Section 73 and 74 speak on the law of damages, whereas the specific relief act talks about other kinds of reliefs that can be taken in case there is a breach of obligation. So the Indian Contract Act seemed to be quite a complete legislation. It talks about what are the rules for formation of a contract. It talks about what are the rules at the time of performance, when performance can be excused, what are the defenses, and then finally it also tells you that what are the remedies in case breach occurs. So interestingly, while the Indian contract law spoke on damages, we later on thought that, look, damages are not necessarily the only remedies that should be given in case of breach. There can be other remedies that should be also made applicable. And hence, a law called the Specific Relief Act was enacted. And later on, it became a 1963 law as amended in 2018, currently as we speak today. So there are other remedies that are defined under the Specific Relief Act, including, probably just to list at this point of time what are the remedies under the Specific Relief Act, in addition to the remedies that are provided by the Indian Contract Act. You will notice that there is something called specific performance of a contract. So you can claim specific performance because you don't want damages, right? So specific performance of a contract, friends, is available when you think money in damages is not something that will compensate your injury due to the breach. And as an aggrieved party, you do not want damages. You want the specific performance of the duty or the obligation that is agreed to in that particular contract. So specific performance, friends, is a special plea. Today, under Section 20 of the Specific Relief Act as amended in 2018, it can become a kind of a mandatory duty of the courts to grant specific performance of a contract. Earlier, before the 2018 amendment, the word that was used was may, and may meant that the courts may grant. And in most cases in India, unfortunately, the courts did not grant specific performance of the contract for multiple reasons, and they were awarding damages. Now, why damages were preferred is because it is easy to quantify the injury in terms of loss, because we say if you can prove damage, then the monetary value of that damage is damages, right? So you can prove damage to your business, you can prove damage to property, you can prove damage regarding the contract value. So you can provide some kind of a proof of that damage, and then the equivalent monetary quantification of the same is damages that is generally awarded to you. However, the Specific Relief Act also notes, as we speak even today, that in certain kinds of contracts, money cannot be an adequate compensation in many cases. And hence, what is agreed in the contract must be performed, and that is when specific performance is ordinarily granted. For example, when you think that you want goods that have intellectual property, money cannot buy any other patented commodity. So when it's intellectual property goods, I think the specific performance of contract can actually be granted as well. So apart from that, I think the Specific Relief Act has different other remedies that can be granted. Quickly mentioning two of them. One is injunction, which courts grant in contracts, and second is what we call as the rectification or cancellation of an instrument as well. So these are possibilities that can be taken in case breach of contract occurs. Now, if you look at the types of breach of contract, friends, essentially, I think it's very important to understand that there are two kinds of breach. One is called actual or present breach, the other is called anticipatory breach. Now, actual or present breach means, friends, that when the time of the contract or the time to perform the contract has come, that is the due date of performance has come and the performance is not done, that is when actual breach of contract takes place. However, anticipatory breach is a very interesting provision in law, which gives an aggrieved party the right to go to the court even before the due date of performance comes, right? So anticipating a breach, right? So anticipatory breach. So, the breach is, say, not yet occurred. It's not certain, but still you are anticipating that the breach is there because there is an expression of that kind of an intention by the other party that he has no intention to complete or perform his contract on the due date. That is when you probably anticipate the breach. Now the question is, if you can anticipate breach, can you actually go to the court and seek remedies even before the due date? That's the real question. And can you file a suit of anticipatory breach in the court, or can you only file suits of actual breach? And you will notice, friends, that if you talk of anticipatory breach, most of the cases of anticipatory breach have to be treated as actual breach. And if they are treated as actual breach, then the remedies are one and the same between Specific Relief Act and the law of damages. So Section 39 probably gives you some kind of an idea about what can be anticipated in terms of performance of a contract. And in case someone who tenders performance, it's good, right? So he has intention to perform. But if he tenders non-performance or expresses intention or a doubt that he no longer will be bound by the contractual obligation, then a case of anticipatory breach can be easily made out from his words or conduct, and that would give the aggrieved party probably immediate right to terminate the contract and claim remedies instead of postponing his remedies at the time when the actual breach takes place. What are the options for the parties in case of anticipatory breach? One is that you can rescind the contract immediately and bring an action, or you need not rescind the contract, but you will wait for the actual date of performance to occur, because maybe there is going to be some change of mind, or I need not hurry. I can probably wait till the performance date is due and then file a suit for anticipatory breach. So this is an option parties can definitely exercise in case of anticipatory breach. Now, to understand anticipatory breach, I think, friends, this Dila Tour case is an interesting one, a very old one of 1852, even before the Indian Contract Act was enacted in 1872. This was a person who was supposed to accompany on a tour to Europe on a ship, and he was supposed to be paid £10 for his services, right? So he was supposed to accompany the tour. He had promised to join the same. However, before the tour could even commence, on 11th May, this person, he informed the tour that he was no longer going to join them, right? So the tour was supposed to start only on 22nd, right? So can someone bring an action before 22nd May, which is the due date of performance of the contract, right? So he was supposed to join only on 22nd, but on 11th May he communicates that he is no longer interested. And can someone actually get in a suit before 22nd of May? Now, in today's time, even if you bring a suit, it takes probably a couple of months before it can be even listed or heard for the first time, or the court accepts your petition. But these were 1852 times, and hence the question was, could that be done? The court said yes, it could be done. Depending upon the option, whether you want to treat it as actual breach means after 22nd May, anticipatory breach means 11th May, when the communication that he will not be interested to perform or come to the contract or to the tour would be the date when a case of anticipatory breach can be made. Now, coming to the remedies for breach of contract, friends, be it anticipatory breach or actual breach, the most common remedy is damages, right? And damages is a kind of a compensation in terms of money or its value for the injury or loss suffered by the parties in a contract, which means the purpose of the contract law is to make promises as binding promises, as enforceable promises, and to impose a penalty if someone does not fulfill his commercial promise. So, to impose that responsibility or liability on the parties is something that the law on damages tries to do. Now, if you look at it in India, there are different kinds of damages that we have seen in different statutes or different kinds of obligations. And if you look at the jurisprudence comparatively, I think you will find this kind or type of damages which are divided into the following. First, we say nominal damage. Right? This is the first type of damage, and this is the most common damages that are awarded in Indian contractual scenario. Second is compensatory damage, which is a little bit kind of over and above nominal. It tries to seek all the kind of proof about your injury. It tries to compensate you, which means it gives you a kind of a satisfactory money value. Nominal damage is just basic money value. Compensation is like a satisfactory money value, which is like making you feel good factor. Right? That's one more type of damage that usually can also be about. The third most important type of damages is called punitive damages. Sometimes it's called also exemplary damage. And this is over and above nominal damage. And the word punitive itself very clearly clarifies the term, stating that it's damages in the form of a penalty or in the nature of something that is imposing some kind of a fine in the name of damages, right? Punitive. So that, probably the breach is intentional, the breach is deliberate, the breach is mischievous. And, if he is allowed to get away just by giving nominal or compensatory damage, there would be a tendency to repeat the same. And hence the court in those circumstances would want to impose a fine or a penalty in the form of damages and say, please don't repeat it again. And that's the reason we are imposing such punitive damages against you. And your actions are so grave and serious that the other party has suffered irreparable damage, and hence you have to pay this as punitive damages. Interestingly, friends, punitive damages are very common in the United States of America. They are common in some other jurisdictions, but very rare in terms of common law jurisdictions that punitive damages are awarded. More so in India, because this kind of damage is not provided for or not allowed vis-a-vis Section 73 and 74. Because you will notice that when you read these two sections, which is the law on damages for breach of contract, these two sections use the word reasonable, and that clearly rules out punitive damage. So the concept of punitive damages is not statutorily backed in India. What is statutorily provided is only nominal damage and not punitive damage at all. And unless the damages are reasonable, it cannot be claimed, is what the law clearly states. The other type of damages that we will have to note is what is known as liquidated damages. And this is provided in 74, and you will notice the distinction between 73 and 74 is 73 is about unliquidated damages and 74 is about liquidated damages. Liquidated means pre-estimated damages. Liquidated means something that has been pre-agreed. It is something that is written in the contract at the time the contract is made, right? So liquidated damages clause are very, very common in government contracts. And you will notice that in every government contract, LD clause or the liquidated damage clause does not cover ordinary breach. It covers breach in terms of delay of performance. That's how government contracts have been designed. So whenever there is delay of performance, government contractual clauses on LD state something like this, that in case there is a 1 week delay, then it's 0.5% of the contract value that will be imposed as LD. If it's the second week, it is 1%. So every week, 0.5% is what you will have to suffer as LD. And the contract price will be directed to that 0.5% or 1%. So you make time as the essence of performance of a contract, and in case the contractor does not complete on the time, LD starts coming into effect. And the clause also caps liquidated damages to 5% of the contract value. That's the maximum that is taken as some kind of a fine, penalty, or what you call as LD, to ensure that there is delivery on time, there is performance on time, and 5% is that he may forfeit from his final payment as LD in case he delays the performance of contract. So that's how liquidated damages are anticipated and pre-estimated to factor in time as the essence of the contract in government, tendering, and public procurement purposes. However, if you just leave the government process aside, and if you look at liquidated damages broadly under 74, you will notice that liquidated damages can be anything that is pre-estimated or pre-anticipated. Like in the past, when we were discussing about employment bond, and I told you that in case you breach the bond, you will have to give 3 lakh rupees as damages. Please note, something that has been pre-estimated or written in the contract, something that the other party says, look, if you commit breach, this is what you'll have to pay me. All that pre-estimated kind of damages that is written in the contract even before the breach occurs is considered as liquidated damages, right? Liquidated is pre-estimated, pre-calculated, predetermined damages. The other form of damages is unliquidated, generally, which is claimed before the courts of law, before the arbitrator, before the courts, when the damage actually occurs, right? And those are punitive, compensatory, and damage. And the interesting facet over there is that even if you say liquidated damages, should it be based on proof of damage? Right? That's one interesting factor that we should consider at this point of time, and we will probably discuss the case regarding the same as we go forward. Now, the rule on damages is very, very important, because if you look at the rule on damages, section 74 is a type of damage, but section 73 is the rule on damages. And section 73 very clearly says that in India, as we speak, under the Indian Contract Act, please note, the law on damages in India, if you look at it from a contractual perspective, is defined into 2 legislations. One is called the Sale of Goods Act, the other is called the Indian Contract Act. Now, if it's sale of goods, under the Sale of Goods Act 1930, please note, which is also a very comprehensive law, which also talks about various remedies for a breach of sale of goods contract, there is something called special damages that are defined. And hence, under the Sale of Goods Act, there is a possibility of granting special damages, which I think is beyond 73's damages that are reasonable. And you could probably claim what we call as anticipated damage or communicated damage, or damages that are known to the other party. That is something that the Sale of Goods Act 1930 definitely provides for. Whereas section 73 very clearly brings in what is the rule of remoteness of damage. It very clearly states that, look, damages that are not direct, right, or what we call as consequential loss, cannot be granted by section 73. So what is damage that is direct from the breach, direct from what has happened in the contract, is something that you can claim. So direct loss can be claimed. Anything that is indirect, anything that is remote, anything that is far-fetched, anything that cannot be foreseen are always remote damages. Remote damages cannot be awarded, right? That's something that section 73 as a rule clearly states. So we always say that in case you expect consequential losses to be covered, you have to mention it in the contract. You have to write it in the contract. You have to define what the consequential losses are. And in case they can fit within what we call as the special damage rule under the Sale of Goods Act, you cannot probably recover the same, right? Finally, it's very important to understand that as per the rules of law on damages, it's important that you definitely have a claim as an aggrieved party, but then when you have the right to claim damages, the law immediately imposes a duty and an obligation. So that's the design of the contract law, isn't it? Wherever it has stated rights, it has always communicated the duties, as the case may be. Now, one of the duties of anyone who claims damages for breach of contract is that he has a duty to mitigate the loss. This is a duty that is clearly visible in section 73. Mitigation of loss is a rule wherein you say that, look, you may have a claim, but don't aggravate the claim unnecessarily, right? You have a duty to mitigate the loss to the maximum extent possible. You have to take steps and measures to see that your loss is curtailed. Just because you have a right to claim breach or right to claim damages doesn't mean you can probably gain anything out of it. So one of the differences for the contract breacher or breaker is that, look, the other party unnecessarily aggravated the losses. He did not do his duty to mitigate the same, and hence he should not be entitled to the claim, is something that they can always come up and do with. So there are counter defenses on the other side, and that is that the claim is without the duty of mitigation of loss, and that is a counterclaim that can always be done in case of breach of contract.